Welcome and thank you for joining part 3 of CIFAR's webinar micro series to kick off the release of the 2023 California Peculiarities publication, 2023 Cal-Peculiarities, How California Employment Law is Different. This final session will cover PAGA peculiarities. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Par Bafayina.
Hi, everybody. Thank you so much for joining us today. My name is Par, and I'm an associate in CIFAR at the San Francisco office. And I'm joined today by my colleague, Daniel Wang, who is a partner in our Century City office. And we are very excited to be speaking to you all today about PAGA. Daniel and I both defend clients in wage and hour actions, both representative and class actions. So looking forward to discussing this beast called PAGA with you today. For those of you that have some familiarity with PAGA, you know that we could spend all day talking about it if we had the time, but unfortunately we only have 30 minutes. So our agenda today is basically, we're going to start by giving you some background on PAGA and what makes it so peculiar. And then we will turn to some recent developments in terms of arbitration of PAGA claims and also in terms of standing issues. And after we cover those, we're going to go into some potential future developments in the realm of PAGA. So let's start with an overview. What makes PAGA so peculiar? Lots of things. So first of all, there is a very minimal standing requirement for PAGA. So basically, to bring a PAGA action, an employee or a former employee need only allege that they experienced a single violation of the labor code at some point during their employment. And based on those allegations, the employee can bring their PAGA claim on behalf of any and all employees for any violation of the labor code, even if that plaintiff themselves did not personally experience that same violation or violations. And then plaintiffs who bring PAGA actions can collect civil penalties on behalf of the state. 75% of those penalties will go to the state and 25% will go to the aggrieved employees. There are no individual damages. PAGA actions are quite similar to key tam government actions in that they permit the plaintiff's bar to step into the shoes of the California Attorney General to enforce the labor code. There is a pre-lawsuit administrative exhaustion requirement, meaning that a plaintiff has to send a letter to the Labor and Workforce Development Agency informing them of their intent to bring a PAGA claim and laying out the violations that they are alleging, essentially. Because a PAGA claim is not the same as a class action, and CAFA does not apply, the California, or the Class Action Fairness Act does not apply, there are barriers to removal to federal court that would not exist in a normal class action. That's another downside to PAGA. And similarly, the regular class action requirements, you know, the showing that a plaintiff has to make of ascertainability, numerosity, all that, those requirements don't apply to PAGA actions. And as we will be discussing shortly, you can now arbitrate individual aspects of PAGA claims, but representative PAGA claims cannot be arbitrated. Next slide, please. PAGA was enacted in 2004, and since then we have seen quite a steep increase in the number of PAGA notices submitted to the LWDA. So you will see on your screens just how many we've been seeing per year. And so with that, we can start talking a little bit more substantively about PAGA. Daniel?
Great, thank you, Par. So the next topic, we'll be talking about some significant developments that occurred within the last year or two. The most significant development being the arbitrability of PAGA claims. There was a Supreme Court decision called Viking River versus Moriana, and this decision was highly anticipated. Leading up to the decision, the issue was whether PAGA claims can be subject to a PAGA waiver, like a class action. And the Supreme Court issued its Viking River decision, which was a bit convoluted. The long and short of it is that PAGA claims now can be divided into two separate components. There is an individual component pertaining to the plaintiff who's bringing the PAGA claim, and there is now a non-individual or representative component dealing with all other employees. The Supreme Court held that, one, PAGA waivers are unenforceable, so it agreed and affirmed that the Iskanian decision by the California Supreme Court remains good law as to PAGA waivers. However, it overruled Iskanian to the extent that Iskanian did not recognize that a PAGA claim can be divided into these two separate components, and furthermore, that the individual component can now be subject to arbitration if the arbitration agreement provides that an individual component of a PAGA claim can be compelled to arbitration. Now, Justice Sotomayor, in her concurring opinion, mentioned a very key component, which was the majority held that once an individual is compelled to arbitrate his or her individual claim, that individual loses standing to pursue the representative component. Justice Sotomayor held that that is an issue of pure state law, and that is ultimately up to the California Supreme Court or the California legislature to decide that issue. Based on that concurring opinion, throughout 2023, there were numerous Court of Appeal decisions that disagreed with the holding in Viking River, saying that based on a decision called Kim v. Raines, which was a California Supreme Court decision, that the plaintiff does not lose standing by being compelled to arbitrate his or her individual PAGA claim if if an employer is successful in compelling that plaintiff's individual PAGA claim. The California Supreme Court, unsurprisingly, agreed to take up that issue, and that was a decision that issued in July of 2023. That case was Adolph versus Uber Technologies. And there, unsurprisingly, the California Supreme Court, which never does any favors for employers, held that indeed the Court of Appeals had it right that the plaintiff does not lose standing if his or her individual PAGA claim is compelled to arbitration, and if the individual is able to establish a single violation in arbitration, then that plaintiff will have standing to pursue the representative component of the PAGA claim. So this is probably one of the most significant developments in PAGA jurisprudence that has happened over the past decade, and certainly over the past 2 years. Next slide, please.
Thanks, Dan. So as Daniel mentioned, this has been quite a groundbreaking development here. We want to talk about the aftermath of this development. And there have been quite a few cases that have come out, but we're just going to focus today on two of them, Duran and Westmoreland. And both of these cases involved arbitration agreements that were entered into prior to Viking River and Adolph. So in Duran, the employer and employee had an arbitration agreement that said claims under PAGA are not arbitrable under this agreement. The employer argued that, in light of Viking River, that provision should be interpreted to mean that representative claims are not arbitrable, and that the court should allow arbitration of the individual PAGA claim. The court denied this request and said that the agreement is very clear on its face in saying that PAGA claims are not arbitrable and they can't do anything to work their way around that. And then in Westmoreland, again, another case where the arbitration agreement was entered into before these decisions came out, the agreement at issue there included a waiver requiring arbitration of wage and hour claims on an individual basis only, and then provided it included a waiver of the right to participate in any class, collective, or representative actions. The agreement also included a savings and conformity clause, otherwise known as a poison pill clause, that said that if that waiver was found to be unenforceable, then the entire agreement would be invalid. And so in this situation, the court held that the agreement was then invalid because it was trying to compel arbitration of representative PAGA claims. And so because of the poison pill language, the entire agreement was invalidated. So next slide, please. Why are we sharing this with you? Because we generally are encouraging employers to consider adapting the language of their arbitration agreements. Take a look if you drafted your arbitration agreement prior to Viking River and Adolph to see if you want to make any changes. So in particular, stating explicitly that individual PAGA claims are within the scope of the arbitration agreement, and then carving out individual PAGA claims from any class or representative action waivers. So what are the potential benefits of individual arbitration? Number one is the stay of the representative action. So you can go and arbitrate the individual PAGA claims, and while you do that, the representative action will be stayed in the court where it was filed. And this in turn can potentially impact plaintiff's counsel's investment in the case, right? Because the penalties for just one employee are not quite the same as they would be if you had the whole group at issue. And then that in turn, again, means that there's just generally less at stake in this individual arbitration. That said, there are some cons to consider, including, the cost of arbitration, and then how this will impact the attorney's fees that you accrue, given that, rather than it being just one action that you're defending against, you'd be defending against two actions. And, that leads to another potential con, which is that given that you're going to arbitrate the individual claims first, and there's a stay happening on the representative claims, that throughout that entire period, every pay period where there's, a potential violation, you're accruing more and more pay periods at issue in the PAGA representative action. So just some thoughts to consider as you review your arbitration agreements. There we go. Daniel?
Yes. So thank you. Now we're going to get to unique standing issues that have come up in PAGA. And I see that one of the questions actually deals with this and is anticipating one of the points that we're going to raise here. Next slide, please. So there are some unique peculiarities that have developed when it comes to PAGA standing. We've talked about briefly the Adolph and the Viking River decisions. In the Adolph decision, there was a reference to this decision called Huff v. Securitas. And Huff v. Securitas held that for standing purposes, a plaintiff only needs to establish a single violation, even if that violation wasn't experienced by any other employee. So in other words, just an example of this might be you have an exempt employee who never received overtime because it's a properly classified exempt employee. That employee, let's say, happened to have some issue with his or her wage statement. Well, under this Huff v. Securitas decision, the plaintiff, the exempt employee, may be able to bring a claim regarding meal periods and unpaid overtime, even though that employee was never subject to those requirements and never suffered those alleged violations. A completely nonsensical decision, yet that was what the Huff v. Securitas decision held and was cited by the California Supreme Court. Now, the other question asked was also, well, then what happens if in the individual arbitration, the employer is able to prevail on some claims, but not on others? Well, unfortunately, under the current jurisprudence, it seems very likely that that plaintiff can nevertheless pursue those claims on behalf of other employees, even if the employer prevails on a particular claim in arbitration. So going back to the example we were talking about with this exempt employee, that let's say that 9 out of 10 pay periods at issue, there was no wage statement issue, but that plaintiff nevertheless can pursue the claim in the representative portion, can still bring a wage statement claim as to all pay periods. Another example might be that you have a non-exempt employee who has filed a claim and the employer is able to compel arbitration of that claim. The employer establishes that that plaintiff never suffered any meal period violations. Nevertheless, that person may have suffered a wage statement violation. Then in the representative portion under current jurisprudence, it seems very likely that that plaintiff can nevertheless pursue the meal period claims that he or she never suffered according to the arbitration that concluded. So there are some unique PAGA standing issues that are raised, and so I hope I've answered the questions that are presented. But just in short, there is no specific economic loss or injury needed. PAGA is just about violations of the law. So even if there was the reimbursement, and reimbursement is perhaps the wrong word. So let's say somebody wasn't paid all overtime owed in a particular pay period, but that was retroactively paid for a couple of pay periods later. Well, there still might be an untimely payment of wages claim, and that could form the basis of PAGA standing, even though that employee did not suffer any injury per se. And under the current jurisprudence, a PAGA plaintiff really only needs to establish that they were employed by the employer at some point and that they suffered a violation. And as we've already discussed, then under the Huff v. Securitas decision, that one labor code violation is all that's needed, and they can pursue any other claims, even if that plaintiff did not individually suffer those violations. If we could go to the next slide, please. Now, what does PAGA standing mean in the arbitration context beyond what we've already discussed? Well, there was a troubling sight in the Adolph decision. And what the California Supreme Court seems to be suggesting, although this is subject to interpretation, but what the California Supreme Court seems to be suggesting is that for standing purposes, it may be enough for a plaintiff to have standing even if that plaintiff suffered a violation outside the statute of limitations for a PAGA claim. PAGA is subject to a one-year statute of limitations because it seeks the recovery of penalties, and penalties under the California Code of Civil Procedures are subject to a one-year statute of limitations. Now, what this seems to suggest, and again, it's subject to interpretation, is that an employee bringing a PAGA claim may have suffered a violation 3 years ago and may not be able to actually recover anything in terms of penalties in a PAGA claim. Nevertheless, because standing only requires that the plaintiff was employed by the employer and suffered a violation, and there is no reference to when that violation may have occurred, that plaintiff nevertheless may have standing. It's just that that plaintiff may not be able to recover any penalties for those alleged violations, but that nevertheless does not extinguish standing. A very convoluted outcome. But what the California Supreme Court did was cite to a decision called Johnson v. Maxim Healthcare Services for support for that proposition. Now, Johnson v. Maxim Healthcare Services involved a non-disclosure agreement that an employee signed more than a year prior to the start of employment. And the Court of Appeal found that that plaintiff did not have standing because the injury occurred outside the statute of limitations of a PAGA claim. The California Supreme Court reversed, finding, at least in part, that one of the reasons this plaintiff could have standing is that that employee was a current employee of the employer at the time they brought the PAGA suit, and that employee remained subject to the non-disclosure agreement that was allegedly unlawful. So in other words, it was a continuing violation that continued throughout the course of employment, meaning that the alleged violation could still have been suffered by that employee within the statute of limitations. But the California Supreme Court in its Adolph decision didn't go through the nuances of the decision, and instead blanketly made a statement suggesting that there is no statute of limitations considerations when it comes to standing for purposes of bringing a representative PAGA lawsuit. Next slide, please. And I will hand this over to Par.
Thanks so much, Daniel. And at first, I just want to say, I know that we went through everything we just went through pretty quickly, but luckily it's all covered in the Cal-Pecs publication. So with that, we're going to turn over to potential future developments in the realm of PAGA. And there are three in particular we'd like to flag, and the first is related to manageability. So as I mentioned at the outset of this presentation, it's not, PAGA is different from class actions in that there is no like affirmative showing that needs to be made in terms of ascertainability and all that the same way you would with a class action. That said, employers have had success in the past in arguing that PAGA claims should be dismissed where they are not manageable. And most notably, there's a 2021 decision in Weston v. Staples where the court dismissed PAGA claims on the basis of unmanageability, a rare decision, but a very good one. And that was a Court of Appeal decision. However, in 2022, a different Court of Appeal reached the total opposite conclusion, which is that there is no manageability requirement for PAGA claims. And that was in Estrada v. Royalty Carpet Mills. And the court in Estrada basically held that there are other ways to get around this manageability issue, and suggested that trial courts limit the evidence that is admitted at trial to ensure that the trial is manageable. And they also encourage plaintiffs to work with trial courts to define a workable group to avoid manageability issues. So for instance, rather than, trying to bring a PAGA claim on behalf of all California non-exempt employees, for instance, it's selecting a particular location or the particular department where the plaintiff was, just to make the action more manageable. But at the end of the day, Estrada held that there is no manageability requirement. And the Ninth Circuit actually came to a similar conclusion in Hamilton v. Walmart, holding that there is no manageability requirement for PAGA claims. The California Supreme Court granted review of Estrada so that they can resolve this split of authority, and we're expecting to hear from them on this issue before the end of 2023. Next slide, please.
Another issue that the California Supreme Court has agreed to take up is whether a PAGA plaintiff can object to a PAGA settlement in other cases. So this is another future development that we are keeping our eyes on and tracking. So the lead up to this issue being taken up by the California Supreme Court is that there was a Ninth Circuit decision called Peck v. Swift Transportation and a state court decision, Turrieta v. Lyft. Now, both cases actually resulted in the same holding, which is a PAGA plaintiff in one case does not have standing or the ability to object to a PAGA settlement in another case. And the rationale behind that is primarily twofold. One is that both cases found there is no individual component to a PAGA case. And I'll get to the interesting notion of that because these cases were prior to Viking River. So both cases said since there is no individual component to a PAGA case, there is no ability to intervene or object like there would be for a class action. So a settlement class member in one case, who's covered by a settlement, I should say, in one case, but has filed a separate class action, they do have the ability to object and intervene because they have a component or their individual rights are at issue in the other case, which is absent in a PAGA case. The second issue or the grounds for the holding were that PAGA cases are different from class action cases in that PAGA is a representative action brought on behalf of the state. So in short, the state is a party to the case, and allowing one PAGA plaintiff who is a proxy of the state of California to object to a settlement in another case would be akin to allowing the state to object to itself. And so because it's an enforcement action and the state is the real party in interest, the grounds for objecting to a PAGA settlement are absent and different than in class action cases. As I mentioned before, the interesting notion, and perhaps the reason the California Supreme Court has taken up this case, is that these decisions predated both Viking River and the Adolph decision, which recognize that there is an individual component now to a PAGA case. Granted, it's still a case brought on behalf of the state of California, but that portion of the Peck and the Turrieta decisions may not be as clear or a valid reason, although there are ways to distinguish that. But regardless, the California Supreme Court has taken up this decision, the Turrieta decision, to decide whether a PAGA plaintiff has the ability to object and intervene in another PAGA case. And this is something we see quite regularly with one of those early charts. There's just been a flurry of letters to the LWDA and PAGA cases being filed. And it's not uncommon at all to have multiple overlapping PAGA cases filed against the same company. And so this is an issue that is becoming more and more frequent that we are seeing. Next slide, please. Now, perhaps one of the most promising developments that we are seeing and keeping our eyes on is the initiative to replace PAGA. The California Supreme Court and the legislature are not doing any favors and nor intend to do any favors for employers. And so matters are being taken into the hands of various interest groups to see if there's a way to reform PAGA through a ballot initiative process. So there is an initiative called the Labor Code Fair Pay and Employer Accountability Act, which will appear on the ballot next year. Now, let me give a brief summary of of the elements of it and what it is, why this could be favorable to employers. So under this act, it recognizes that the PAGA actions are really a cancer for employers and are really focused on being a shakedown to employers who may not have ever willfully violated any laws, or perhaps not even violated any laws, but the costs and potential exposure for losing even on a single alleged violation for a small number of pay periods are astronomical. And so what this initiative is seeking to do is to focus on willful violators by allowing double penalties for those willful violations, right? And really focusing again that the statute should be focused on those who are willfully violating the law rather than those employers who are in good faith trying to comply with the laws. Now, this initiative also recognizes that it's plaintiffs' fees and plaintiffs' lawyers that are driving this. And so in a creative way, what this initiative is seeking to do is requiring that any PAGA claims have to be submitted to the labor commissioner via a complaint, and that the DLSC, a division of the labor commissioner's office, would have to be a party to all labor complaints. Now, the question is, well, why would this be favorable to employers? Well, the answer lies in a unique aspect of this process that exists under the Labor Code for submitting claims to the labor commissioner. Those are referred to as Berman hearings colloquially. And under these Berman hearings, attorney fees cannot be recovered. So if a claim or a complaint is submitted to the labor commissioner for resolution, there cannot be a recovery of attorney's fees under the statute. Furthermore, this places now the responsibility back on the labor commissioner, which was the entity and office that was primarily responsible for enforcement actions. PAGA was only enacted because the labor commissioner's office didn't have the resources to pursue these claims. So this is now a proposed compromise where the labor commissioner's office would still have to have a stake and a role in the enforcement of any alleged violations, but that it's not going to be responsible for seeking out and locating these violations. A complaint would nevertheless still be filed by, it can be a plaintiff's lawyer or a potentially aggrieved employee, but it's putting the process back into the hands of the labor commissioner. and again, mentioning that the key component is that there would be no attorney's fees available, and that the intent behind that, quite obvious, is to take the incentive out of these plaintiffs' lawyers and hopefully having PAGA be what it should be, an action that's really focused on egregious violations rather than being a mechanism to enrich the plaintiffs' lawyers. And another aspect of that is to try to get all the fees to the, all penalties to the employees and not to the state, which is the current rubric under PAGA. And I see that we are already out of time. I'm going to announce the CLE code. The CLE code for today's presentation is SS, as in Saifar Shah, SS 9714. Again, that is SS 9714. For any questions that were submitted that we weren't able to get to, we will be in touch with you in the next few days. We want to thank you for coming to today's very short presentation on PAGA peculiarities. Thank you very much.